Hello and welcome to the News Minute. The past week, the Madurai bench of the Madras High Court saw unprecedented scenes where a bench led by Justice GR Swaminathan had wanted to initiate contempt proceedings against advocate Vanchinathan, who had alleged caste bias and religious bias against the judge. For the first time in the history of Tamil Nadu, 8 former justices of the Madras High Court had come out and questioned that entire process. To talk about this, I have with me Justice Chandru. He is someone who had represented the 8 judges. Before I go across to him, here is a quick reminder: News Minute Tamil and News Laundry. We are a complete ad-free platform. We are not dependent on ads from political parties, governments or corporates. We are dependent on you. And to discuss about these issues, it takes a lot of resources, time and energy. So if you like our work, do become a paid subscriber of the News Minute and support independent journalism. Sir, thank you so much for talking to us. Can a judge hear a case in which he is interested? Is that something acceptable?
It's a very general question. There are exceptions to the rule. The normal rule is no judge can be a judge of his own cause. And the part of the principles of natural justice is not only to be done, but seen to be done. Therefore, it's not mere rendering justice. There is a procedural fairness. In that sense, a judge cannot hear his own case. And also, a judge cannot hear his own near relative's case. Because there is a rule in the Bar Council that near relatives cannot appear before the judge. The rule says before the court, whether the court means the whole court or the judge, now there is an understanding that it's only the judge. Therefore, I can appear in other courts. Now, these are all the general exception. But there is a legal exception. Suppose you commit a contempt of my court. Then the exception comes in. I can hear the case. Now, when you say contempt, the contempt is of twofold. Civil contempt and the criminal contempt. Now, civil contempt, you disobey my order. It's very impersonal. There's an order that you disobey. Therefore, I punish you. That I can punish. You will have to say why you have not followed my order. Either you can say you are going on appeal, or you're filing a review, or something like that. You can have an exception saying, I am not the fellow. That is how you will find number of IAS officers, secretaries, collectors are summoned for disobeying the order. That's civil contempt. But the criminal contempt has got a different procedure. The procedure is, since criminal contempt is quasi-criminal, any person who is summoned, he will be treated like an accused. So he has the protection under Article 21. His liberty, the procedure has to be followed. Now you will have to take cognizance of the contempt, then issue notice to the person who is responsible for committing contempt. How do you take cognizance? Again, there are two different varieties. If the contempt is in my court, suppose you start shouting, you misbehave, I can punish you there itself. Just make you to stand, put the question, record your question, and then impose a penalty. If it is beyond the court premises, where in some other media, some YouTube, some newspaper, then it has got a different procedure. He can't take cognizance. He has to write a letter to the Chief Justice, and the Chief Justice may take note of the fact, and then if he feels that it has to be inquired, he will constitute a bench. Not necessarily the same bench, judge, anybody. 2 judges will be constituted. Once a division bench is constituted and the reference comes from the Chief Justice, then a notice goes to the person who appears. After he appears, they issue a show cause notice to him, asking for reply. Once the reply comes, they will have to frame charges. What are the charges against you which incidentally result in contempt? After it is done, you will have to pass an order and then question him on the penalty. Now there are two penalties are contemplated. You can be sent to jail for 6 months or 2,000 rupees fine or both. Now this is what the contempt. In case it is a punishment for jail and you want to file an appeal to Supreme Court, then the sentence is suspended automatically. You can go to Supreme Court. That's only a. In case the order is passed by a single judge, then the sentence is suspended. You can go before a division bench. Automatically, the sentence doesn't come to operation. Now there is a procedural safeguard which cannot be violated. Suppose the judge does not take action, but there is a serious contempt, and some member of the bar feels that the interests of the judiciary protected, then they must only go to the Advocate General, ask for his permission to move the contempt. Now the Advocate General refuses, no court can interfere with that. The Advocate General permits, then you can file a petition. Then notice goes.
Okay.
What like a private complaint?
What prompted 8 former judges of the Madras High Court to come out and question this process? Because, Vanchinathan was summoned in the court. He was asked for a clarification, but he wanted in writing. And then there was another date that was set. Before that, 8 judges came out and they questioned this entire process.
I feel the retired judges don't leave the court premises forever just because they are retired. They are also, since their experience as judges, they are also bound to give sage advice to the new incumbents. And we consider that's our moral duty. There is no statutory duty. So when I saw this in the media, I felt it's something wrong. The judge should publicly reprimand and ask for some explanation when there is no proceeding against Vanchinathan. I don't even know Vanchinathan personally. And I only knew that he has sent a petition to the Chief Justice of India making allegations against the Justice Swaminathan. Swaminathan is actually sitting in a division bench. The allegation is only against Swaminathan, not against Justice Rajshekhar. Now, in such circumstances, nobody knows the contents of his petition, but from the way Swaminathan questioned Vanchinathan and also wrote in his order, the substance of the allegation seems to be that he was communally biased and he is not fit to decide matters. Therefore, he requested the Chief Justice of India to constitute an inquiry. Now, the inquiry procedure is evolved over the period. There was a Chief Justice in Bombay High Court, Bhattacharjee. He got some money from some royalty from some Middle East, some shady agencies. And the Bombay Bar decided to ask him to resign for this. This was shown in the account. But they found the book has got disproportionate income. They felt it is unfair. So they passed a resolution that Bhattacharjee should resign, but he didn't resign. The entire Western Maharashtra High Court Association, the entire western coast of, they went on strike that Bhattacharjee should resign. And Bhattacharjee finally resigned. By the time Supreme Court took note of lawyers' direct action against judges being removed. So Supreme Court, Justice Ramasamy passed a very lengthy order in Ravichandran Iyer versus Bhattacharjee. It's reported as a judgment 1995. That we have evolved an in-house procedure. Though the Chief Justice is the administrative head, he may not have a direct contact with the High Court as a higher institution. But once a complaint is addressed to him by any person relating to misbehavior of a judge, if it has got a prima facie opinion, then it can constitute a 3-judge committee, which is called in-house procedure, which nobody will know what is the outcome of the procedure. And the in-house procedure, the consequent report, if it founds prima facie case against the judge, then the Chief Justice can take action. That is the procedure. The Supreme Court warned no lawyer should have any direct action in these matters. It is the only procedure. Now, what the Chief Justice can do after the in-house procedure, which you saw in Yashwant Verma's case, he was retransferred to Allahabad. He was denied any judicial portfolio. He was sitting idle and drawing money. And then he recommended to the Parliament to start impeachment action. So, any judge can be removed only by impeachment, not by any other method. So, impeachment is contemplated for Supreme Court judge under Article 124, The same procedure for High Court judges under Article 217. And now then it becomes, that is why the Vice President Dunker said, the judiciary has no role, only Parliament can rule, which is true. A decision to remove a judge is entirely left to the Parliament. Now there is a minor safeguard. The Parliament, when they take up the impeachment motion, with the minimum numbers are behind the motion, they will have to constitute a Judges Enquiry Committee under the Judges Enquiry Act 1963, 3 judges. One will be a Supreme Court judge, one will be a Chief Justice of the High Court, one will be a jurist, 3-member. Now, Judges Enquiry Committee gives a report. If the report is in favor of the judge accused, the motion lapses automatically. If it is against the judge and there is a prima facie case, then the Speaker of the House convenes a joint session of the Parliament to discuss the motion on the basis of the report. After discussion, if 3/4 members were present, the majority decides to impeach him. He gives order of power. Such attempts have been made against Justice Dhanakaran, Justice Swaminathan, but then on the day of the voting, they resigned. So the motion became infructuous. But then they were removed from the office. That's a different issue. Now, what is the important issue is, Vanchinathan allegedly has sent a petition to the Chief Justice of India containing a number of allegations and suppresses, in which case only Chief Justice of India has to decide. Nobody else can go into the issue. Suppose the allegations are against me. I am not supposed to verify what allegation you said, whether it is right or wrong, and make a judicial proceeding. Now, first thing is, in that circumstances, the judge has no power to decide, number one. Number two, he was sitting in a division bench. The second judge has got nothing to do with these allegations. No, he now takes it upon him to summon Vanchinathan. Vanchinathan was not expected to be present. There was no written order. Now a case comes before him in which originally Vanchinathan appeared for some respondent. Now he is absent because he has returned the papers to the client. He is not.
He is no longer a party.
He is no longer part of the case.
Yeah.
So he calls him and then say, I heard that you have been doing all this. There's a circulation of, do you think I'm communally biased? Tell me. Which means it is one of the allegations which is there in the memorandum, which only Chief Justice has to find out, and Vanchinathan has to answer before a 3-judge committee if and when it is constituted, not otherwise. Therefore, when we saw all this development, we found that it will bring disrepute to the judiciary if these proceedings go on. Because if a court adopts a wrong procedure, then it also brings disrepute to the entire judiciary, not to the individual judges. Therefore, some of us, actually, I asked some of my colleagues who are retired judges, I asked them through WhatsApp message saying this is not correct. Ravichandran Iyer procedure should be followed. Do you think we should appeal to the judge? Out of several judges whom we made a statement, 8 judges responded. One now subsequently retracted. That's a different issue, but that's going to sidetrack the issue, whether 7 or 8. If no judges sign, I would have issued a statement. That's a different issue. That when something is wrong, something is procedurally wrong, something not to do with the judicial proceeding, but something with the outside the proceeding, then it is our duty to call the issue to order, saying what you are doing is wrong.
Okay. Justice GR Swaminathan in his orders.
No, it is similar to, for example, in a parliament, speaker decides for the Lok Sabha, chairman decides for the Rajya Sabha. Suppose they make pass orders, does it mean nobody can criticize? Though there is something called privilege of the House. The privilege of the House stops where the liberty of the citizen enters.
So in his order, Justice Swaminathan says that the judges were interfering in the judicial process. So that's a charge.
It looks as if the reading of his order shows that he's a little perturbed. At the same time, he was also mixing up issues. A retired judge participated in a meeting and also gave an interview. That's a different issue.
She said it's contempt.
Our appeal, where I am party to the appeal, where I signed on behalf of all the judges, ours is only limited. Any judge with their allegation against him and a petition is sent to Chief Justice of India, he has lost any control over that petition. Therefore, we told the judge to be keep in order. Please stay off until the Chief Justice decides. That's all. Suppose he has made comments on other judges. For example, even our appeal, he said, I am not bothered about this appeal. Tell those judges, I am not a fool. We don't consider anybody as a fool. In fact, Justice Kerala leader Jayarajan called the Kerala judges as Chumbamar. He was punished for contempt for 6 months. It was reduced to 1 month. He went to jail for saying that. Therefore, I said, somebody told me about this. I told them, Justice Swaminathan is not Lord Denning. Because the Times paper said the judges who decided the case are all fools. So a contempt action was brought on before Lord Denning. He said perhaps the papers may be true also. And he did not proceed with that. Therefore, I am saying many things may be said. Since you are deciding the rights of parties, you are susceptible for criticism. Sometimes the criticism may be fair. Sometimes the criticism may be unjustified. Sometimes the criticism may be uncivilized also. That's different. So how you react? Normally, we don't react to such public criticism because several times such allegations have come. It's not the first time an allegation of communal bias comes. In fact, long before, in the 50s, Justice Chandra Reddy of Andhra Pradesh High Court was accused of deciding cases in favor of his own Reddy community. And there are people who were aggrieved because in Andhra this is very famous. Petitions were sent to Chief Justice. That was a time when the Constitution has come into force and there was no other guideline and there is no in-house procedure or anything like that. The Chief Justice was perturbed by the complaint. At the same time, he wanted to do something. So he deputed Gajendra Katkar to Hyderabad to find out whether such allegations are true, because no judge immediately believes when a judge says communal bias. It has to be proved. So Gajendra Katkar in his biography writes, when I went to Hyderabad, I didn't have a clue how to go about. And I'm very certain that High Courts are not subordinate to the Supreme Court in the administrative side. Judicially, they are bound to obey my order. We are not their supervisors. Therefore, I am also content that I can never let this go, because whether I am doing a work in accordance with Constitution or not, I am not proved. After a long thinking, I called the very judge himself, Chandra Reddy, and told him there are some complaints. I am not on the complaint. I am bound to tell the Chief Justice something now. Therefore, I am of the opinion, you just give the names of some 10 senior lawyers whom you have paid. I'll speak to them. So he gave 10 names and he called each lawyer to his guest house. And it so transpired, all the 10 lawyers confirmed the allegations against Chandra Reddy. And it is not a time the parliament to take action. There was no such procedure because Supreme Court was never had the idea. And then what they did was, under Article 222, you can transfer a judge. So Chandra Reddy was transferred to Madras, and we got a first time a judge from Andhra to Madras High Court. And nobody knew why he came to Madras High Court. Later, reading Gajendra Katkar's biography, we knew there was no procedure and the lawyers were faithful in reporting. And then the court could only think of transfer. Transfer is not an answer, but that was a temporary answer. So here, so I am only saying, it is not as if judges are above all this. There were allegations of communal bias, not necessarily Brahmin bias. There can be any other community also. There is allegation of bias and court took action against it.
So in this case, Advocate Vanchinathan sending a petition to the CJI is not wrong. That's something that he could have done.
That is the established procedure. After Ravichandran Iyer's case in 1995 Supreme Court, there is no other procedure contemplated except sending a petition and wait for the Chief Justice to take action. So, in fact, in the case of Yashwant Verma, even though petitions went, Supreme Court took suo motu notice, not necessarily any petition. Suo motu notice, they constituted the in-house committee.
But in the order, Justice GR Swaminathan says that, the petition was never the issue here. The issue was the criticism that Vanchinathan was doing on several social media platforms and all that.
May not be on the basis of record, because on the first day when Vanchinathan was questioned, there was in circulation in social media the very same petition.
Okay.
So the judge asked that question that you are circulating certain things against me. So from the questioning, the basic irking factor was the petition. But the next day, when we all made this appeal, that the procedure of Ravichandran Iyer, in-house procedure to be followed. In the final order that he has passed, he has said that there is also other misconducts. If there is other misconduct also, since the misconduct of the lawyer did not take place in his court hall, before this bench, the question of any summary procedure is not contemplated. He has to send it to the Chief Justice. In case of criminal contempt, only Chief Justice of the decide. The constitution of the bench, taking cognizance of the complaint, and then proceeding with the contempt. Therefore, what the Swaminathan did on the first day may be wrong. What he did on the second day may be right, except the unwanted statement made against the lawyer, making him like a comedy piece and all that. That's never. While you may have 1,000 grievance against me, I have no grievance against anybody because I am sitting in the seat of a judicial seat where I should just ignore all these things. Where we are never perturbed by what you say. Somebody calls me by name. All right, so it is. That's all right. Ultimately, in any judicial order, it is the judge who signs the order. So the most powerful person is the judge. He need not be feel very upset. In fact, the most important quality, he is a judge who decides a case. He should not be upset about any issue. And since if he feels that his feelings are more overtaking, best thing is for him to transfer the case to some other court. In the normal cases. But in this case, he has no jurisdiction at all because it has to go to. Now it has gone to Chief Justice. Let Chief Justice decide what he does.
But also at the same point of time, you talked about judges getting perturbed by criticism, criticism that is there on social media. Today people have a platform to express their opinion, and even judges are not an exception on social media, is what I see. But there is also one thing that judges expressing themselves, their ideology, their ideological positions, and all that. Is that something that we should be concerned about?
There are two things. When Victoria Gauri appointment came, the Madras lawyers challenged it, saying that she has made a hate speech, therefore she is not a fit judge, not suitable. There are two things for to become a judge. You must have qualification and you must suitability. Now the suitability is decided by the High Court Collegium, then goes to Supreme Court Collegium. Remarks are called from the judge from that state, consultee judge, and thereafter Supreme Court Collegium decides and recommend to the state government, central government. Central government advises the president to issue. Now in Victoria Gauri case, when the case was filed, they gave the petition to Chief Justice Chandru, who immediately constituted the bench, saying that I cannot decide because I am the recommending authority. He constituted a bench comprising of Justice Khanna and Justice Gawai. These are the two next in order to become Chief Justice. Now, when the matter started arguing, the bench said, we will go into the question of qualification alone. Suitability is not our decision. So they removed the suitability portion. She is qualified. Nobody says she is not a qualified. If you are a 10-year High Court lawyer, you are qualified. Now they cleverly sidetracked the issue. But later, Chief Justice Chandru was giving a lecture in Harvard University. He said, in India, we do not stop anybody becoming a judge on ideological grounds. Number one, a pre-ideological position is not a criteria for us to decide. This is a statement. And Krishna Iyer became a judge, though he was a leftist. There are two fallacies on this. First thing is that Krishna Iyer did not become judge because of his ideology. He was appointed by the Chief Justice in consultation with the central government. He was a member of the Law Commission, and that was the full process. But Krishna Iyer's background, everybody knows that he was a minister in Nambudripad minister, and he is active politicians and all. But he was not a member of the Communist Party. But at the same time, when Krishna Iyer was appointed, the bar protested, including the attorney Jaswali Zorabji, who was a Bombay bar president. After 20 years, they regretted. They also gave him a statement. He's such a good judge. We unfortunately protested. That's a different. A judge makes himself acceptable by his office. Now, in Victoria Gauri's case, there are records that he spoke like that. The question of suitability, you say that collegium decides. What is the mechanism that the collegium adopts? Was the collegium was posted with this matter? Was it really that? If suppose you don't go by pre-appointment ideology, there is a John Satyan, whose name was recommended 3 years back. And the only objection was the government sharing the information that in the Facebook posting, there was a critical references to the Modi government. That's all. The Supreme Court Collegium rejected it after seeing the report also. Normally, we don't get access to this report, but then in the Collegium minutes, which was put in the website, they have mentioned this is what they say. Now, 3 years have gone, John Satyam is not appointed. Therefore, it is this pre-ideological position is always a factor, and the union government has a bigger say in these matters. What is acceptable to them, the name will pass. What is not acceptable to them, their name will be rejected. Therefore, you can never say ideology can be filtered at all. If the ideology closer to the government is accepted, the ideology not closer, why it can't be accepted? In fact, I remember once I was speaking to the West Bengal speaker, Halim. He was also a law minister. I said, why you have been in power for 2 decades in West Bengal? Why no leftists are coming to judges as a judge? He said, whenever we make a recommendation, they'll be rejected. So what do? We do negative practice. If we don't like somebody, we'll recommend them so that the hope it will be released. So we are doing negative practice. So the collegium appointment system, we'll have to talk separately. Because
okay. I understand that. But also there is this criticism or concern where several advocates or people who are in the legal profession.
In fact, before you go to the exam, in fact, I wrote, Victoria Gauri will escape the net, but not John Satyam.
That's true. But it doesn't stop there, sir. There are also, concerns that have been pointed out that judges attending meetings of certain organizations that have taken questionable stands in the past. So, how do we see all this?
It is impossible for a judge who studied law and who practiced law for more than 10 years to become a judge not to have a view. Everybody, in fact, the former Delhi Chief Justice, in his biography he writes, he was a leftist in the student movement. He says it's difficult to shed all this. But the point is, when a case comes, we don't bring our ideology. We decide what is there before us. At the same time, when the issues which we have more attachment, our judgment also get trained like this. For example, gender neutral, gender bias, or issues relating to women, Adivasi, or scheduled caste. You must have a proactive attitude. You should not say no at all. Therefore, there is, in fact, recently I was reading Lohia. He says, what is wrong if you say that everybody is equal? You may push the OBCs and Dalits backward, because historically they were backward. So this kind of equality business doesn't work. You must have a passion for them. So even for IAS officer, there is a confidential role. In that role, one question is, what is the attitude of this officer against scheduled caste and scheduled tribe? His officer has to write. Why such a monitoring is required? Because you are trampled upon the rights of the people. And then if you have a bias in it, may work against a very constitutional principle. Therefore, I also feel, in fact, after my retirement, I wrote a book on my judgments on caste and religion. And how to name that book? Title is important. So I said, my judgments in the light of Ambedkar. When I wrote like that, many people are shocked. And one of the TV anchor asked me, if you say that your judgments in the light of Ambedkar, somebody will say gold worker. What do you say? I said, I don't care at all, because today I can say with certainty that if you want to write on caste, if you want to write on religion, you got to read Ambedkar. Yeah. And extensively I quoted. I always think that I'm the only fellow who did that. Recently, Chandru released a judgment Sukanya Shanta's case, 2004. They went into the caste practice within the jail. In that judgment, there are more than 20 quotes from Ambedkar's selected works. And then he writes that the constitution has buried Manusmriti, one of the most striking statement which no other judgment is ever made in India. The High Supreme Court now, based on Ambedkar's writing, says that the constitution has buried Manusmriti, which is very, I think judges must have an ideology which is working for the larger good of the people. I am only saying the ideology doesn't come into your decision making because you are molded. You can't remove the your brain and go to the work. That's not possible.
But judges also making
One thing is important. I always say, at the time we take oath under Schedule 3, it says that I shall uphold the Constitution without fear or favor, without ill will, to the best of my knowledge, which means I must uphold the Constitution. But GR Swaminathan has seen, speaking in several platforms, not in the court, that this Constitution is old, is a copy-paste of 1935 Act, and if the proportion between Hindus and Muslims of 1947 is not maintained, the Constitution has to be scrapped. He has said all this in public meetings, which I feel that is more dangerous than sitting and deciding matters. Therefore, as long as you are a judge, you got to think your oath is important. You believe this Constitution.
Okay, my last question, sir. There are also some judges who have made references to religion, and religious quotes are being, are being echoed in their judgments. How do you see this? Like,
that is why I'm saying we have no filter to remove people who don't believe in Constitution. They do take the oath and do the opposite. This is something. That is why there is a judges accountability bill which is pending in the parliament for the last 20 years, not been passed. If a judge acts against the ethics of the office, there must be a procedure to take action. We cannot simply have people. There are many people who have been removed for their position in Western countries that took a very strong position on matters which are to be there. In our even our values which has been evolved in 1999, the judicial values for the judges, which is a voluntary code. There is a code which says that you shall not decide matters of which you have your personal understanding. You must understand you are holding a public office. But how many people follow this value, we do not know. And therefore, we should have an ethics committee for the judges also. That unless that you can't pull up judges. There must be a statutory mechanism to pull up judges.
Right, sir. Thank you so much for joining us and explaining to us what exactly has happened in Vanchinathan's case, and also why did 8 judges of the Madras High Court, former judges of the Madras High Court, question this entire process. Thank you so much, sir.
Thank you.